Hearing the appeal of Sharp's summation from liquidation against Halimeda International Limited.
Yes, Mr. Morgan.
Yes, may it please your lordships. You know the representation in this case. You have an electronic hearing bundle. There is also a key documents bundle. Unless any of your lordships would like me to, I was intending only to refer to the electronic hearing bundle page numbers.
Yes.
I have marked up my key documents bundle, so if any of your lordships do want the references in there, I can hopefully provide them. I hope your lordships have also been provided a supplemental bundle of authorities over the last day or so. That includes a handful of additional authorities and also some proper reported versions of some of the cases which are in.
Yes. Can I just ask, we've got a couple of handwritten additions to our list of counsel. Andre Mackenzie and Janelle Stewart. Are they counsel for the appellant?
Yes.
Thank you.
From Harneys, my lord.
Yes.
I'm going to be addressing the court on grounds 1 to 3 and issues 1 to 3. The board has asked to be addressed also on the question of the statutory test for appeals.
Yes.
I'm not sure if your lordships are wanting to have oral submissions on that issue. If you are, from our side, Mr. Fradley was going to deal with that in, subject to my timekeeping, up to around 10 minutes.
Yes.
That would be helpful.
I think so.
I'm grateful. And we've agreed a timetable which hopefully your lordships have. It's reasonably tight.
Yeah.
And given that, I don't propose to address you on the facts to begin with, but to filter the facts through as we go through submissions insofar as necessary.
Yeah.
So, my lord, issue 1, what is the correct test? What I propose to do, my lords, is to start off with 5 preliminary points, which I'm intending to be broadly responsive to points that have been made against us in the respondent's written case. My lord, point 1. Obviously, you've seen that we rely upon Salford Estates as a cornerstone of our case. There is significant criticism, both of the reasoning and the approach and the effects of Salford Estate from my learned friends. We'd just like to make the following initial observations about that. First of all, and starting off with a small point, it was a strong court. It was the then Chancellor, later Master of the Rolls, very experienced commercial judge, Lord Justice Longmore, and Lord Justice Kitchen, later a Justice of the Supreme Court. Next, my lords, that was decided over 9 years ago. Now, respondent's written case is put on the basis that Salford Estate offends insolvency policy and is problematic. Well, they haven't put before your lordships any textbooks or articles arguing to that effect or identifying problems that have been experienced with Salford Estates, particularly in England.
I was going to ask about that, if there had been critical commentary on the case.
Well, there's certainly none that's been put before your lordship.
Mm. We have been known to go and look at the books on our shelves ourselves.
Yes, I think Mr. Fradley and I identified one article, which I think was written by a student, I think, that went into the LQR. I think it's right to say that it didn't identify any different arguments than are made, for example, in the Dayang case in Hong Kong, which my learned friends rely upon as part of their submissions.
Is that the Claudia Quack 2021 LQR?
Yes.
Yeah.
But have there been issues in relation to exclusive jurisdiction clauses, how it applies in that context?
In terms of textbooks and articles?
No, in terms of the authorities.
Yeah, well, that's one of the preliminary points I was going to deal with, my lord, and perhaps if I could deal with it in a moment. We recognise that that is something the board is likely to want to make some reference to. It's a difficult issue to deal with in some respects because the law is in a state of flux, particularly perhaps after Guy Lamb, which we say is broadly favourable to our position in relation to arbitration clauses. But I'll come back to that if I may. My lords, in England, well, of course, High Court judges have been bound by Salford Estate.
Just before we leave that, I think speaking personally, I would find it helpful to know if there's any literature out there that can help us. But obviously I realise you're not going to have that now, but I would have thought it would be helpful if there is anything that we should have our attention drawn to it.
On the exclusive jurisdiction clauses?
No, on the general point about
Yes.
Salford Estates and how it's gone down, should we say.
Yes, certainly we can provide copies of those.
Thank you very much. Or even just references.
My Lord, High Court judges have applied Salford Estates and indeed expanded its application without any creed or cause as to the effect it may be having on practice at first instance. We have Eco Measure, which is a case referred to in our written case. The Deputy Judge referred Salford as placing a heavy obstacle in the way of a petitioner. We have Field Fisher, where Miss Justice Nugee, now Lord Justice Nugee, extended the application of Salford to applications for administration orders, therefore outside the province of winding up. And then in Reed Telnick, the then Chancellor, Sir Geoffrey Voss, in 2020, applied it in a cross-claim situation. And obviously by that stage he'd been Chancellor for a number of years, and he didn't identify any problems it was causing in practice. And following on from that, my Lord, the point we're going to develop is that Salford Estates, we say, has been followed, or at the very least been very influential in Malaysia, Singapore and Hong Kong, which we'll have to come back to. Your Lordships will be well aware that in the recent Privy Council case of Family Mart from Cayman, the board referred 98 to 102 to Salford Estates with what we regard as apparent approval in the context of that part of the case which concerned the discretionary stay. And then finally, my Lords, we know that Parliament has had an opportunity, if Salford Estates was wrong, to address it from both sides. Firstly, my Lords, the Corporate Insolvency and Governance Act 2020 introduced significant changes to insolvency law. That didn't seek to address the Salford Estates point. And your Lordships may be aware, and we've included it within the supplemental bundle, that there is going through Parliament at the moment an arbitration bill. There's nothing in the report that led to that, or in the arbitration bill, impinging on the question of the Salford Estates approach.
Is it discussed at all in the Law Commission?
No.
No.
No. So, my Lord, what we say is that Parliament's had an opportunity to address these matters if it was in truth causing real difficulties or was contrary to principle. It hasn't done so, and the suggested difficulties, we say, either don't exist or are significantly overstated. My Lord, that then leads on to the second preliminary point. We do say that the authorities in Singapore, Malaysia and Hong Kong are helpful and point firmly towards a test in line with, or at least close to, Salford Estates. And my Lords, perhaps because the authorities undermine the respondents' arguments, they've tried to take, we say, an overly narrow approach to the relevance of those authorities. In the respondents' written case at 63, they say, that's page 852.
852?
Yes. They say that the relevance of foreign precedent is the persuasive of otherwise of its reasoning. And I think they cite in support of that an article written by Lord Reid in 2008. Well, Lord Reid, I'm sure, knows his own article, but as we read that, it in fact identifies three reasons for referring to foreign decisions. Firstly, the foreign decision is itself persuasive, regardless of its reasoning. Secondly, to obtain information about the success or otherwise of a legal solution tried elsewhere. And then thirdly, which is the point the respondents do refer to, the persuasive reasoning, the source of ideas. And my Lords, we say that all three are in play in this case by reference to those foreign authorities. Just unpacking that a little, if I may. As to the first use, namely persuasiveness of itself, we submit that the context is important here. The Board is concerned with the meaning and effect of arbitration acts in different jurisdictions deriving from obligations under the New York Convention and in response to the adoption of the uncontrolled model on international commercial arbitration. We say in that particular context, it's relevant and helpful for the courts to learn from each other as to their respective approaches. This is not a domestic context like Australian libel, such as in the Australian urine case, which we'll perhaps come to later. My Lord, we seek to draw support from Lord Hodge in Family Mart. I'll perhaps just give you the references at paragraphs 28 and 31 as to that process, and more generally in the well-known expression from Lord Neuberger in FHR, which we've referred to in our written case at 81. That's page 814. My Lord, the second use, to obtain information about the success or otherwise of a legal solution, we say is relevant. Picking up with my first point, other respective jurisdictions have adopted a test or an approach which is the same or similar to Salford Estates, which indicates, we submit, this form of legal solution is not, as the respondents would say, problematic. Thirdly and finally, my Lord, we do say the reasoning of the courts elsewhere, in particular perhaps the reasoning of the Singapore Court of Appeal in Ann, which is a five-man court, was persuasive. The third preliminary point we submit is that Salford Estates and the authorities from the Commonwealth show that there isn't any conflict between arbitration policy and insolvency policy. We say that can be put within the framework of the threshold question. But even if there is, it can be reconciled within the framework of exceptional circumstances or similar controls. We recognise that the Commonwealth cases haven't taken always exactly the same approach as Salford Estates, but it's nevertheless, we would submit, very similar. In Ann, my lords, they identified the test or the exception as being if there was an abusive process. Malaysia was, I think, spot on with Salford Estates, exactly the same. In Hong Kong, we've got a range of different approaches, but certainly recently in Gai Lam, they enforced the ECJ unless there was a risk of insolvency affecting third parties or a dispute that bordered on the frivolous or the abusive process. One of the questions the Lordships may have in due course is whether or not exceptional circumstances includes abusive process. We would, just putting a marker down, would accept that exceptional circumstances would include abusive process. That leads on to the next question, what is abusive process? Perhaps I can park that one for the moment. My fourth point, picking up Lord Hamlin's question, is the relevance of a case law on choice of law clauses, or EJCs, where the law is not entirely settled, we would say. The Lordships will be aware that outside the insolvency context, where you have ordinary court proceedings, the law is settled, at least in England and in the BVI, by reference to whether or not there are strong reasons not to grant the stay. We have Donoghue in this country in the Supreme Court. We have Garkusha in the BVI to same effect. Otherwise, it's a point I'll probably come back to. But in this context, it would seem that the merits of the case, where one has an EJC, have no relevance, or very little relevance.
I think you said choice of law clause. You meant...
Choice of court.
Yes. Yeah.
If I did, I apologise. I meant to say choice of court.
Yeah.
My lords, in the insolvency context, in the different jurisdictions, in the BVI, the leading authority is still Spar Cassa, where they decided where you have choice of court provision, in that case, I think, in favour of Austria, you apply the genuine and substantial test. And my lord, that approach found favour with the Court of Appeal in England in BST properties. I don't know if the court has recently had occasion to look at that decision, but I just wanted to perhaps just show you that briefly. to identify the limited, if any, reasoning behind that conclusion. My Lords, that's starts at page 1170. Your Lordships will note from the first page that the appellant appeared in person. Whilst he had been represented below, he wasn't on appeal. And in fact, the reasoning is simply one paragraph, and that, my Lords, is paragraph 31. I could perhaps invite you to look at 1177.
Clause 18 is presumably an arbitration clause.
The exclusive jurisdiction clause.
Oh, sorry, yes.
In favour of Hungary, for what it's worth. My Lord, one can see there wasn't any argument or any significant argument about the point, and no real reasoning behind it, with all due respect to Lord Justice Jonathan Parker. And that decision preceded Salford. And your Lordships will have seen, I think, in particular from my learned friend's written case, that there have then been disputes at first instance in this jurisdiction in England as to whether or not judges faced with winding up petitions should follow the Salford approach or the BST approach. My Lord, we then have in Hong Kong the decision of the final Court of Appeal in Gai Lam, which was where there was a bankruptcy petition presented in Hong Kong, if I put it this way, in the face of an exclusive jurisdiction clause in favour of New York. And the leading judgment, the judgment was given by Miss Justice French, and he came to the conclusion, I'll perhaps come back to the reasoning in due course, that the strong cause or strong reasons test was basically the approach in winding up in bankruptcy as well, although he observed that that test shouldn't obscure the range of considerations of the court. And what we take from Gai Lam are two things. Firstly, in essence, I'm not saying there aren't some subtleties, the arguments which my learned friends run in this case in favour of insolvency policy as against the supremacy arbitration were the very similar arguments that were run in Gai Lam in favour of winding up as against the exclusive jurisdiction clause, and they did not find favour with the Hong Kong Final Court of Appeal. The second point is, my Lord, it seems difficult to see, as in Hong Kong now, you would get less protection for an arbitration clause when faced with winding up proceedings or bankruptcy proceedings. In other words, it seems difficult to argue that at the very least it would be a strong reason to stay or dismiss the there have to be strong reasons not to stay or dismiss the winding up petition in Hong Kong. We note that we're still waiting a final judgment from the Hong Kong Court of Appeal in the case called Simplicity, which I think very directly raises the question of interaction of winding up an arbitration. But there seems to be, in our submission, a very strong steer from the Hong Kong Final Court of Appeal in Gai Lam as to where that's going. And my Lords, just concluding this point, holding parties to their agreements we would accept is a feature of both exclusive jurisdiction clauses and arbitration. And to that extent, they have that much in common. And I think that leads my learned friends to say, well, we should be looking at the BST approach even in relation to arbitration. But our submissions are this, my Lords, that unlike exclusive jurisdiction clauses, arbitration clauses have a statutory underpinning in relation to both the policy and the substance of the protection. And one can see that difference being expressed and the weaker protection for a debtor in ordinary court proceedings, strong reasons not to stay, as opposed to the automatic stay under Section 9 or Section 18, depending on which jurisdiction we're in. And it would seem to follow in our submission, my lords, that the approach to the discretion in winding up need not be the same, and the court could, if it felt it needed to, afford greater weight to arbitration clauses in formulating the discretionary test, if the court is persuaded that exclusive jurisdiction clauses should be treated differently in that respect. Well, finally, in point 5, we just wanted to pick up the outline of the argument of my learned friends that there may be a reason for BVI law being different. They make some preliminary points in their written submissions at paragraph 13, which your lordships will find at page 835. And they list a number of points. My lords, the first point is that the courts rarely, the BVI parties rarely give jurisdiction to the BVI courts. We know just in passing that in the Garkushka case, there was in fact an exclusive jurisdiction clause in favour of the BVI, which shows it does happen. But anyway, my lords, if you choose a foreign court, well then the issue in our case doesn't arise. If you choose an arbitration in a different jurisdiction, we say that reflects the party's own choice. In subparagraph 2, they say prevent the BVI courts from protecting the public. My lords, we would hope that the board would proceed on the basis that England is a jurisdiction which seeks to protect creditors. And that hasn't stopped the development of the Salford approach. We would additionally note it begs the question as to whether the petition debt is due, which is the threshold question which I will come back to. And my lord, they then say that the BVI is a creditor-friendly jurisdiction. We're not quite sure what this means, or how helpful that is in the board determining the issues which it has before it. I mean, one could equally say that the BVI is a business-friendly jurisdiction, tending to attract company registrations by its low regulation and low tax regimes. Part of that attraction may be so that people can see that arbitration is a policy upheld and supported in the BVI. What the board in my submission hopefully has a clear point, which actually has a firm evidential basis, is the BVI, like England, updated its Arbitration Act in response to Unker trial in order to make the significant change, including to remove the power of court in ordinary proceedings to remove the ability to give summary judgment. And we say that is a clear evidential point of the support of arbitration in the BVI, as opposed to somewhat speculative and unhelpful phrases. Finally, my lords, they say we're wrong to label the BVI as an outlier. We don't shirk from saying it is an outlier, my lords, in terms of the jurisdictions which have the same or similar arbitration provisions, which have considered this issue. It is the only one that retains, clearly, the genuine and substantial dispute test. If one has a spectrum of cases with Salford at one end and Jinpeng at the other, the authorities in Singapore, Malaysia, and the weight of authority is very firmly at the Salford end of the spectrum, rather than the Jinpeng end. So, my lords, those are my overarching points. Can I then proceed to get in more details the interaction of winding up and arbitration? And my lords, what we propose to do before going any further is to set out what we say is the framework and the stages by which a court determines a creditor's winding up petition. And that's the same in England, the BVI, and I think the other jurisdictions that we've been looking at. Lord, stage one, question, is the petitioner a creditor? We say that is a jurisdictional point. Stage 2 is the company unable to pay its debts. Again, that's a jurisdictional point. You can't make a winding up order without that being satisfied. And then stage 3, there's the discretion. Comes from the word may. Should you make a winding up order? My Lord, we submit that structure, and we're going to unpack it and then apply it, is the appropriate way of looking at it, and then to decide what the Chancellor was doing in Salford, at which stage he was at. It also helps to inform how the case was approached in Jinpeng and also in the present case. My Lord, at stage 1 in more detail, now, the court could, on a winding up petition in each case, decide on the balance of probabilities whether the debt was due or not. As a matter of practice, as the court knows, it doesn't usually do so. It instead asks the threshold question, outside the arbitration context, of whether or not the debt is disputed on genuine and substantial grounds. And the same approach is adopted to cross-claims as well. And my Lords, it's well established that this is the same test, effectively the same test as summary judgment. We've referred to the vendor traders case, which was a BVI Privy Council case in our written case, and I don't think that's in dispute. And the 3 reasons for that approach were given by Lady Justice Appellant in the Botley Grange hotel case. She said it was for 3 reasons. 1, to stop abuse by unfair pressure. 2, there's insufficient time to canvass all the relevant evidence, often in response to a winding up petition or where one is seeking an injunction to restrain presentation. And 3, the company's court procedure is not designed for lengthy or complex procedures. And it seems that the first of those reasons is the key one, the most important. That's what Lord Hoffman referred to in Parmalat, and it's what the Chancellor referred to in Salford Estates. But we wouldn't like the other 2 to be lost sight of entirely. But, my Lords, it's a matter of discretion. And so there are circumstances in which the court may choose to finally determine the dispute as to the existence of the debt on the petition. Lady Justice Appellant recognised that point, and so did Lord Hoffman in the Parmalat case. And what we submit the court is doing in each case is exercising a discretion as to how far it will allow the question of the dispute to be explored. My Lord, in support of that proposition, could I take you to the supplemental authorities bundle, which I hope you have?
Have you got the reference for Lady Justice Appellant?
Yes, my Lord. It's the Botley Grange hotel case at paragraph 8. And you'll find that in the authorities bundle starting at page 1138.
Thank you. 1138.
Yes.
Thank you. And now we're going to the supplemental.
Yes, and I hope your Lordships will find at tab 3, page 38, a decision of the Privy Council in Brins Limited. This was a rather remarkable case where at first instance the judge in Australia had a 4-week hearing to decide the petition.
What page are we on?
My Lord, the report starts at page 38.
38. Thank you.
Can I just ask, on the page you took us to a moment ago in the last authority,
Botley Grange, my Lord.
yes.
Yes, if I...
In paragraph 7, she says, it's not in dispute that it's not the practice of a company's court. I mean, this is familiar. She's saying it's not in dispute, but it's not the practice of a company's court to resolve disputes in relation to the liability to pay a petition debt. Generally, the court restricts itself to determining whether the dispute is genuine and based on substantial grounds. And if it is, the normal practice is to dismiss the winding up petition. Now, if that's, I mean, that's familiar enough. I'm just wondering, given that that is what happens in winding up petitions, would a winding up petition fall within the scope of the arbitration clause?
Lord, it's a point I was going to come on to later, but we're not going to argue that simple presentation of the winding up petition is a breach of the arbitration clause.
No. So what? It's when you get to the stage of the proof of the debt.
Well, we've got the presentation of the winding up petition, and if a winding up order, we've got proof of debt.
Yeah.
But obviously, we've got then the decision stages 1, 2, and 3 on the winding up petition. And I was proposing to identify how we say the exercise of discretion and arbitration act fits in with that at that point. Okay. But we're not going to be saying presentation of winding up petition equals breach of arbitration agreement. No. That would seem to be contrary to at least what the Privy Council said in Family Mart. And I'll just add to that. We don't suggest it was any part of the Chancellor's reasoning in Salford. It didn't found on a misconception that the presentation of the winding up petition would be a breach of the arbitration agreement. That's not what he was saying. Lord, are you happy for me to come back to that point?
Yes. I mean, what's going through my mind is essentially that winding up isn't a procedure for dispute resolution.
No, but it's not often, but it can sometimes be used if the court, and this is the point we're coming on to, there are circumstances in which the court does decide on the winding up petition to finally determine the dispute about the debt. That was an example in Brins, which I hope your lordships have got in the supplemental bundle. Well, that was the case, I say, rather perhaps extraordinary. There was a 4-week hearing where the judge heard all the issues and finally resolved whether or not there was a debt. And then one of the parties complained that he'd done that. And met with a rather tart response that having gone through 4 weeks, really didn't have much choice but to make a final decision about whether the debt was due or not. My Lord, if I can take you to page 43. I hope your lordships can find in actually the bottom right-hand quadrant a paragraph which says, "It is a matter for the discretion of the judge." And I was just going to invite your lordships to read that and their approval of what Miss Justice Gibbs had said in the QBS case.
I mean, it's inconceivable that this sort of approach would be resorted to as a matter of discretion if there was an arbitration clause that was effective and capable of being operated.
Yeah, so effectively the discretion might lead you to say, I've got all the material, it's a short point of construction, I'm going to resolve the dispute finally. This exercise discretion might just say, we're only going as far as seeing if there's a genuine and substantial dispute. The discretion might be, as an arbitration clause, we're not even going to go there at all. But it's all part of the same discretionary exercise as to how far you allow the question of the dispute to be considered and or determined by the court. I don't think time will permit me to take your lordships to it, but Miss Justice French said a similar thing in the Guy Lamb case, in particular at paragraph 100, page 1676. Again, this question of how far you allow the merits of the dispute to be considered.
Well, one might think that one comes back to the construction of the arbitration clause, that the clause doesn't permit anybody other than arbitrators to decide the substantive question of debt or no debt, as it's put here. But is it a breach of the arbitration clause to consider whether there is, in fact, any dispute to be determined?
It's what I'm going to come on to after I've set out the stage, a bit more about stages 1, 2 and 3, but just to, our argument does not rest entirely, or indeed perhaps at all, on it being a breach of the arbitration agreement. But we do say there's a good argument that in certain circumstances there is a breach of the arbitration agreement, which reinforces the argument we're already making.
You say in circumstances where the debt is determined or some other circumstance?
We certainly say that if the debt is determined, that would be a breach of the arbitration agreement. Because you have sought determination of an issue which the arbitration agreement says should be determined by arbitration. Just to flag up a point now, and what I'll need to develop, because they may need to develop it, is that we don't see any reason why you couldn't ask the arbitrator for a declaration that there is no genuine and substantial dispute about the debt. Lord Hodge in Family Mart recognised the ability to go to an arbitrator and ask for a declaration which doesn't consist of the award of money or the like. So when the court is saying there is no genuine and substantial dispute, it is certainly trespassing across territory, which could form part of perfectly proper arbitration.
But why would that be an issue in an arbitration?
Well, you'd ordinarily just get the debt determined one way or the other, I accept.
Yeah, but it's not a relevant issue in the arbitration whether genuine and substantial dispute.
Yes, but, my lord, in Family Mart, freestanding issues were hived off to the arbitration, whether or not being breached down in trust and confidence. That didn't go anywhere within the arbitration other than for the arbitration to determine. You then came back to court. We would submit there's no conceptual difference between the arbitrator determining whether the debt is due, making a declaration there's no substantial dispute, and then coming back to court and winding up, and the court deciding its powers in that respect.
But in that context, there was a substantial dispute on the matters which the Privy Council thought could be sent to the arbitrators.
Yes.
That appeared to be common ground.
Yes, I think there must have been, because Section 4 in the Cayman Islands preserves the old provision that you can give summary judgment even in.
Yeah. But I mean, it was common ground throughout that there was a substantive dispute. The question was where it should be adjudicated.
Yes. And
there was no question of asking the arbitrator to make a declaration of no substantive dispute or anything of that kind.
no, but we say that the principle still holds good. You can ask an arbitrator to make a declaration which doesn't necessarily involve the granting of relief in terms of a debt.
I mean, it's absolutely vital, I think, to the argument, because if you couldn't, I mean, if it's an issue that couldn't fall within the scope of the arbitration clause, then the arbitration clause isn't any obstacle to the courts deciding it. So I think that you have to win on this proposition.
Yeah. Lord, perhaps I can set out some more points and then come back to that in more detail. Stage 2 in the winding up exercise, the court does decide on the balance of probability whether the company is unable to pay its debts. And often, as the court knows, the non-payment of the petition debt will itself be relied upon to establish its solvency. And therefore, the assessment of whether the dispute is genuine and substantial will also be relevant at stage 2. Though, of course, if you have a single creditor case, as we do here, in a sense that's academic because you don't get past stage 1. My lord, stage 3, the discretion, there's not much to add at the moment. But we would say that suggestions that once you've established stages 1 and 2, you get an order almost of right is perhaps putting it too high. The discretion certainly extends to whether the petition is an abusive process, It also extends to ascertaining the wishes of creditors and contributories. But it also would seem that the court has discretion whether to adjourn or stay to take into account the possibility of alternative processes. For example, whether to stay to allow a restructuring plan to be proposed, for a CVL, or indeed for administration. And we would say that point reflects that a policy in favour of rescue, general statutory policy, has an effect on the way that the court exercises its discretion in winding up. No one expressly said you must alter the way you exercise your discretion in winding up because of the existence of a restructuring plan. But that's an adjustment that the court has made to its practice because of those new legislation. And we say there's, in a similar way to the Chancellor in the Salford, said you have to adjust insolvency practice in the light of changes to the Arbitration Act. Moving then to the situation where you've got an arbitration clause and the winding up or bankruptcy. Our submission is that the court should, as a matter of discretion, decline to consider the threshold question of whether or not the petitioner is a creditor for the purposes of stage 1. And we say in substance that's what the Chancellor was doing in Salford. And the reasons which I'll come to in a moment were his justification for doing that. That those reasons apply at stage 2 as well was confirmed by Miss Justice Nugee Infield Fisher, although we would, with respect to Miss Justice Nugee, say he was wrong not to also apply them at stage 1. My Lords, in support of those positions, we rely on the judgment of the Singapore Court of Appeal in Annan, in particular at 71. Your Lordships find it helpful to look at that?
Yes, thank you.
So, my Lords, that's page 1025. And perhaps I can invite your Lordships just to cast your eye over that, insofar as you haven't already.
Yeah, I'm not myself at the moment sure that this approach based on assessing the competing policy interests is really the right approach. The effect of the arbitration clause is contractual, and the objection to the court's considering whether there's a genuine substantial dispute is that the court is said to be failing to give effect to the parties' contract. Clearly, the court should give effect to the parties' contract. So it seems to me boils down to what is the effect of a contract?
Yes. Well, I hear what your Lordship says. Perhaps I should go straight now, I think.
I mean, that's just a personal reaction at the moment.
Well, perhaps I should go to the reasoning of the Chancellor in Salford. And no doubt that may provoke some further observations from your Lordships. Just for your Lordship's reference, that paragraph in 71 was explained in a subsequent decision of the Court of Appeal of Singapore in Founder Group. I can give your lordships the reference at page 1509, paragraphs 31 and 35 to 36, where they confirm that this approach of actually judicial restraint applied at both stages 1 and stages 2, as I've described them. So, perhaps then the answer is to come to Salford, which your lordships will no doubt have noted the facts of, and in particular to then the argument in relation to discretionary stay, which is at page 2287. Anticipating your lordships have obviously looked at this already. Paragraph 39 effectively states his broad conclusion that, save in wholly exceptional circumstances, policy should be exercised consistent with that embodied in the 1996 Act. And then at the end of 41, he says, effectively, for the reasons given, you should either dismiss or stay the petition. And then the reasoning is contained at 40 and perhaps part of 41 as well. And I think it's been said there's 3 reasons. I think there may, perhaps on analysis, be 4, but it doesn't matter precisely how one divvies it up. Lord, the first reason given is that it would be anomalous to conduct a summary judgment type analysis. And that reasoning has been largely adopted by Singapore in Annan and also Hong Kong Final Court of Appeal in Gai Lam.
But it's not the same as summary judgment, because it's not a judgment or determination.
No. Well, I agree with your lordship. If it's suggested that, I think it's been suggested that the Chancellor misunderstood the nature of it. I don't think that's what's being suggested. I mean, he was clearly aware that it was not a summary judgment, because he says it was a summary judgment type analysis.
Yeah, but why does that matter if it's not doesn't lead to a judgment? It's not trespassing on the arbitrators, is it? There's no determination.
Yes, well, he says, I think it's because he then goes on to say further on, when the creditors agreed to refer any dispute relating to the debt to the arbitration. So he's identifying in my submission the tension between the summary judgment type analysis on the winding up in preference to the dispute being resolved in the arbitration. Now, that's only part of his point, because he then goes on to explain why that would cause problems. And his point number 2.
At which paragraph?
That's paragraph 40.
Thank you.
So point 2, we would say, is then inevitably encourage the parties to bypass the arbitration agreement. Point 3 is the pressure. And then, arguably, at point 4, contrary to the parties' agreement as the proper forum for the resolution of such an issue, to the legislative policy of the 1996 Act. So, Lord, just going back then, in relation to point 1, and going back over a territory we briefly discussed earlier, the Chancellor said at the end of 41, it was right for the court either to dismiss or stay the petition so as to compel the parties to resolve their dispute over the debt by their chosen method of dispute resolution, rather than require the court to investigate whether or not the debt is bona fide dispute on substantial grounds. And so that would illustrate in my submission the Chancellor clearly had in mind. He was comparing an investigation of the dispute in the company court as against a resolution of the dispute in arbitration.
But you don't have to resolve the dispute for the purpose of the winding up proceedings. So why are you requiring them to go off and resolve it?
Well, in response to that, I'd say this. First of all, as we've identified, there may be circumstances in which the court would consider it appropriate to finally resolve the dispute. If it was a short point of construction.
Not if there was an arbitration clause. That's to my mind, the possibility that in some other completely different situation, not involving an arbitration clause, the court might actually grasp the nettle and resolve the dispute, when it obviously wouldn't do so if there was an arbitration clause, doesn't seem to bear very heavily on the question which we're faced with.
My Lord, it's helpful to know how your Lordship's originally seeing it. But in my submission, the very fact that the court, it's within the court's power to decide how to resolve, deal with this matter. The possibility that if it opens the door to considering the issues, it may decide that the best way of dealing with it is by finally resolving it, is a reason sort of not to open the door at all, and to stop the inquiry at an earlier point in time.
And is that at all common, that the winding up petition would lead to a determination of whether the debt is or is not owed? Or is this highly unusual?
It's certainly not common. I would certainly accept it's unusual. Whether highly...
I'm trying to remember if I've ever come across it.
Yes, the Botley Grange...
There are cases where it has happened.
Yes, and probably where it happens are more likely to be cases that might be reported. But certainly the Botley Grange case is one, the Brins case is one. It does...
But it's never happened when there's been an arbitration clause.
There's no reported case that we're aware of that deals with it. But we would say that would be a clear breach of the negative obligation. In other words, an obligation not to have the matter referred to arbitration, a matter which would be referred to arbitration, determined by the court. But going back to a point which I appreciate probably didn't find immediate favour with Lord Hamlin, even if the court is determining there's no genuine and substantial dispute, that is a dispute that could be referred to arbitration. Lord Hodge, perhaps I take you to the passage in Lord Hodge and Family Mart where he referred to declarations. Lords, I think we'll find that at 1456.
Sorry, one?
Page 1456. Paragraph 94.
I think I must have taken down the wrong page number. Did you say 1546?
1456.
1456, I beg your pardon.
Your Lordships prefer to read 94 and 95 rather than me?
Yes, if you give it a moment.
And perhaps 96 as well.
Yes.
So, my Lord, we do say that provides support. I'll be bold enough to say strong support for the proposition that even if the court is only considering whether it's a genuine and substantial dispute, that is a matter that can be resolved at arbitration, either by a declaration in those terms, or, of course, the resolution of the issue finally. And, my Lord, in Mozambique, Lord Hodge described his own decision in Family Mart in these terms, and perhaps I can take your Lordships to 2241. Paragraph 70.
70?
Yes. the second sentence. The board holds. The board holds in the law of the Cayman Islands, legal proceedings may be stayed to obtain an arbitral determination in the form of declaration of a substantial factual dispute, which is an essential step in the legal proceedings.
But what's there being talked about is a declaration about the answer to that substantial factual dispute, not whether there is one.
Yes, well, Lord, is the question of the status of a debtor, the creditor, and the debt a substantial factual dispute, which is an essential step in the winding up proceedings? My submission, it is. The court has to make a decision about the status of the creditor and of the debt, however it phrases itself, whichever approach it takes. And without that, at stage one, you can't get a winding up order, either because you're not a creditor or the court's not satisfied to the appropriate standard as the absence of a dispute. And we submit that, leaving aside issues of public policy, and insolvency, which we accept doesn't apply in the same way in a member's winding up petition, those matters, it's the same, it should be the same approach. And my lords, we note that, for example, in the arbitration bill that's going through Parliament, there's a new provision, Section 7, introducing a new Section 39A into the Arbitration Act to make it clear that arbitral tribunals can grant summary judgment, which we say is consistent with what Lord Hodge said about robust case management so as to avoid undue delay, matters such as that. And my Lord, returning to Salford and reason one, we say it's not based on the Chancellor concluding it would be a breach of the arbitration agreement. But if your Lordships consider that as an important or a necessary step, we would say that the possibility of the court determining it and the taking away from the tribunal of the right either to consider whether there's a genuine triable dispute as a declaration or to decide the debt point is, to that extent, a breach of the arbitration agreement. Lords, the second point was what was described as the encouragement to bypass the arbitration agreement by presenting a winding up petition. And what the respondents argue, my lords, is that that's not a standard tactic in litigation. It's a solution in search of a problem. Well, there's pretty limited incentive to present a winding up petition instead of ordinary court proceedings, absent an arbitration clause, because you can get summary judgment. What we say the Chancellor was identifying was this tension. If you don't bring the practice in the Companies Court broadly in line with what happens in ordinary proceedings, is the perverse incentive to go down the winding up route, because you can avoid the no summary judgment point under the Section 9 stay. Lord, the third point the Chancellor makes is improper pressure. And again, similar reasoning is picked up in Annan at 63 and 72. And what we submit is it's objectionable over and above the ordinary pressure on a debtor who cannot rely on an arbitration clause, because it does operate as to undermine the parties' agreement that a dispute be resolved in a different forum with its own particular characteristics of privacy, flexibility, and a bespoke procedure. And so well, we do say that the Chancellor's 3 and 4 points are sound and have been adopted with respect to jurisdictions around the Commonwealth and reflect the points that he makes as the tension that's then created, has been created by the changes to the Arbitration Act by removing the ability to obtain summary judgment. And this is, how shall we put it, an appropriate response of the Insolvency Court to that change in arbitration law. Lord, I think a point that's made against this is it said that arbitration policy is just simply not engaged at all. That may underlie the questions that your lordships have been putting to me. But we do say that the reasons that the Chancellor gave, the arbitration policy is engaged, because otherwise you have things being funneled into winding up, pressure being applied in the way that he describes, and trying to avoid what Section 9, the mandatory stay, seeks to achieve in ordinary court proceedings. And we say there's no displacement of the insolvency jurisdiction, in the same way that there wasn't in Family Mart, in that one can have the hiving off of specific issues to be dealt with by the tribunal, and once resolved, to come back to the Insolvency Court for the winding up order to be made.
But you accept that Section 8 doesn't apply, is that correct?
Yes. In the same way that obviously Section 9 didn't apply in Salford, and likewise the equivalent mandatory stays in the provisions in Singapore, Hong Kong and Malaysia. And what we submit is that
But isn't a consequence of your argument that Section 9 ought to be applicable? Because you're really arguing, ultimately, that there ought to be a mandatory stay, are you not?
We'd say there is the mandatory stay is a mandatory stay, and subject to how the law develops in the light of Lord Hobbes's observations that there may be some exceptions to the mandatory stay. It's either absolute or very close to being absolute. We would accept that the court has a greater power to intervene outside Section 9. The Chancellor described it as exceptional circumstances. He couldn't, at that stage, he said, envisage what those circumstances would be. The benefit of subsequent case law is that that has identified possible cases or examples of exceptional circumstances which propose to address your lordships on in due course. And we would accept that in certain circumstances, notwithstanding the arbitration clause, a winding up order will be made in circumstances where there would not be a stay under Section 9. We do accept a graduation of approach. We do not say it's the same thing. And that is justified by the fact that the court has a discretion under Stage 3 to make a winding up order. And that discretion should be informed by the policy under the Arbitration Act, in the same way it's informed by the policy of rescue culture. And therefore, winding up orders are not made in circumstances in which they might otherwise be made.
But the respondents say if it's outside Section 9 or 8, then it's outside the policy underlying those sections.
Yes, and yes. Well,
and international arbitration practice, which those sections reflect.
Yes, I mean, obviously if they're right, and it's obviously entirely a matter for your lordships, a number of very eminent judges have got it very wrong in a number of cases.
Or those who followed Salford Estates. we talking about, or something else?
Well, so the Chancellor was wrong,
Right.
the Court of Appeal was wrong, and a number of other judges in different jurisdictions who've considered it in detail are also wrong as well. And of course, that's entirely open to your lordships to find that. And we say they didn't all. They
But
haven't.
what's the answer to the point about policy, though? If you're outside Section 8 and Section 9, where's your policy coming from?
The Arbitration Act is not a complete code. So, for example, in AES, there was an argument that the Arbitration Act was a complete code, and therefore the court didn't have power under Section 37 anymore to grant an anti-suit injunction. And the Supreme Court rejected that argument for a number of reasons, including that the policy behind the Arbitration Act was to increase support for arbitration, whereas concluding that Section 37 no longer applied because it was a complete code would in fact reduce protection for arbitration. So that illustrates, my Lord, how arbitration policy can have an effect on the exercise of the court's discretion. Shall we grant an anti-suit injunction, anti-suit injunction?
But what is the relevant policy here if Section 8 and Section 9 don't apply?
The relevant policy is that, as explained by the Chancellor, you are going to have inappropriate and unintended consequences to force people to pay up debts, which they would not otherwise do, and to feel or put under pressure, which they would otherwise do, if...
That's not part of the arbitration policy, is it? I mean,
that's what the Chancellor
Arbitration policy is presumably at the highest level of generality there to ensure that where parties have agreed upon how to resolve genuine disputes between them, that those disputes are resolved in that way.
Yes.
But if there isn't a genuine substantive dispute, doesn't seem what arbitration policy is there that would say, well, nonetheless, you shouldn't be able to have recourse to a class remedy called winding up, which only operates where there's no substantive dispute. Because an arbitration policy designed to deal with situations where there is a substantive dispute.
Well, I mean, Section 9 was amended so as to remove the ability to summarily determine the dispute. So it was no longer enough to effectively say there's a genuine substantial dispute. It's enough to say not admitted. And the problem is if you don't carry that through, in some respects, we would accept, in response to Lord Borough's comments, some adjustments. It's not the same as a mandatory stay. If you don't carry it through, you are going to either cause a breach of the arbitration agreement, or you're going to subvert the policy behind it, and to cause people, rather than to arbitrate their debts and to decide whether they're due or not, to cut through and to present winding up petitions with all the problems that is, as the Chancellor identifies as being caused by it. Well, I accept that is essentially the nub of this in terms of the arbitration policy. To what extent can you read from the Arbitration Act and the changes a directive or an indication that the Insolvency Court should adjust its policy in the way that the Chancellor did? And an experienced Chancery judge, the Chancellor, thought it was appropriate to adjust the way the court approached the discretion at stage 1. My Lords, I probably just looking at the time, picking up. Would I perhaps would the court find it helpful if I referred you to whether there's a conflict between the respective policies between the arbitration and insolvency, and to deal with the possible exceptions under exceptional circumstances?
Yes, thank you.
Because this is the other point that's made by my learned friends. Insolvency should effectively trumps it in any event. Lord, I think the first thing to note is the Chancellor was aware of this in Salford Estates. He referred at paragraph 37. Which is page 2286, by letter B. By contradistinction to a 994 petition, which was a private dispute in relation to the affairs of a solvent company, which therefore neither engaged any public policy objective of protecting the public, where a company continues to trade despite being unable to pay its debts, nor involved a class remedy for the company's creditors. So the Chancellor was obviously had well in mind the potential issue about creditors. We do submit, as we put in our written case, and I'm not going to repeat this, you could address it through the threshold question. Are you a creditor? That rather begs the question which we say should be determined in arbitration. Even if it gives rise to some tension, we do say that can be regulated by the safety net of exceptional circumstances. I indicated earlier, my lords, that it does include, we would accept, abuse of process, which the lordships may say what is included within abuse of process. My short answer would be that is to be determined on a case-by-case basis. But authorities have identified certain areas which may fall into that category. My Lord, first of all, the question of admissions. We would invite the court to say, firstly, to follow the approach of the Chancellor in Telnick, where he rejected past admissions as being an abusive process, as long as they had by then been retracted. Indeed, we observed that if they hadn't been retracted, it's difficult to see how there would be a dispute at all. But in the alternative, which is the Ann approach, where they did say an admission in relation to liability and quantum could give rise to abuse. They did qualify that, my lords, and this is paragraph 94 in the judgment, by saying there could be a clear and convincing reason for a change of position. And one can see that by reference to a simple example. Plant and machinery is delivered pursuant to an agreement which contains an arbitration clause. The debt falls due, the debt is admitted, and then 2 weeks thereafter, the plant and machinery blows up, and it's obvious then there's a very large cross-claim. The fact that you'd admitted the debt 2 weeks previously should not stop you then from relying on that cross-claim for the purposes of defending the claim. My Lord, secondly, the Chancellor in Telnick did identify possibly a failure to engage in the arbitration process as being an exceptional circumstance. I think in Ann they put it on the basis of no genuine desire to arbitrate or to try and stifle it. Lords, we would say if the arbitration is afoot, it should be preeminently for the arbitration tribunal to regulate its own procedure, and not for the court to second-guess that. Secondly, if the arbitration is not afoot, generally that would be irrelevant. The Supreme Court in AES said that granted injunction, even though the applicant in that case expressly said it had no intention of commencing an arbitration. But we would accept there may be some circumstances in which the failure to commence arbitration, depending on the facts, could fall within the exceptional circumstances or an abuse, but that would be fact-specific. My Lords, in Ann they recognised waiver or estoppel in relation to the right of pursue an arbitration. We would have thought that might fit rather better under whether the arbitration gateway was engaged at all. In other words, does the dispute fall within the arbitration clause? Is it still operative? And then finally, my Lords, a number of cases have referring to staving off concerns in relation to creditors. So, should the insolvency regime be invoked. And we accept there may be circumstances in which, notwithstanding the arbitration clause, the insolvency regime should be invoked in order to protect creditors. And that would be a particular difference, for example, as opposed to the mandatory stay. My lords, you also have the fact that in Salford, the Chancellor said that even where there weren't exceptional circumstances, it was still open to the court to stay the petition rather than dismiss it. And that would allow, for example, the appointment of provisional liquidators or to preserve avoidance dates in respect of avoidance transactions. My Lord, and just going back to Lord Burroughs' point, we said this is not a mandatory stay by the back door. Admissions, risk to creditors, failure to engage with the scope of failure to engage with the arbitration would not be matters that would fall within any exception to the mandatory stay. My Lords, I had a further section on whether BVI law should be different. Would your Lordships find it helpful if I made some brief oral submissions on that?
Yes, it would be. I mean, if we're dealing with a matter of discretion, then there's an issue about whether this court should be compelling the BVI judges to exercise their discretion in a particular way.
Yes. Well, my Lord, I mentioned earlier that my learned friends have relied on the case of Australian Consolidated Press and Urim, which was a case of this court in concern with libel. And the court may recall that the board held that Australian law as to exemplary damages had not been changed by the recent decision in Rooks and Barnard, as it then was. In other words, the existing Australian domestic approach should continue to apply. What we say is that the Australian Consolidated Press case is authority for three propositions. Perhaps if I set them out, and if the court would like me to take to the passages, I will do so. But first of all, the court should bear in mind, should take into account three factors. Firstly, whether the law in that jurisdiction is settled or well settled. Secondly, whether law developed on the basis of misconceptions or faulty reasoning. And thirdly, whether the issue is of a domestic or international nature. Those are the three propositions we say we get from that case. Would the court find it helpful for me to take you to the relevant passages?
If you perhaps give us the references.
Yes. My Lord, the first proposition, it's 1106, and it's letters D to E, and 1113, letter G. Misconceptions or faulty reasoning is 1114G and 1116C to D. And the question of whether the issue is of a domestic or international nature is 1113C to G.
Sorry, the third one again.
1113C to G.
Thank you.
My Lord, we say that each of those matters, in fact, point in our favour on this discrete issue. First of all, the question of settled law. My Lords, in Urim, the law in Australia had been settled since 1920, when the matter came before the Privy Council in the 1960s. So there's no doubt it could be said to be settled. In the BVI, Sparcassa settled the genuine substantial test in 2003, but that was not in the context of arbitration, and it was predated the BVI Arbitration Act 2013, which we say introduced significant policy change in the same way as the English Section 9. And Jinpeng itself was decided in 2015, so it's only been around for something less than 10 years. So very different situation. My Lord, the second point about misconceptions and faulty reasonings. You've seen in our written case that we say that Jinpeng didn't properly understand what the Chief Justice was saying in the C-Mobile case. We put that in our written case, but it might perhaps just be unhelpful, but it might be helpful for me to unpack that a little. My Lords, I think one needs to take a step back. In C Mobile, there are two decisions. The first one, which I'm not going to ask you to look at, is at tab 21 in your electronic bundle, page 1202. And that was an appeal against a refusal to set aside a statutory demand. My Lords, in the BVI, as in Hong Kong and England and other jurisdictions, you can apply to set aside a statutory demand on the basis of genuine and substantial dispute, or on some other ground. And they are discrete provisions. And what happened in that case is the creditor applied to set aside the statutory demand on the genuine and substantial ground and did not apply to set it aside on the general discretionary ground. And at the first decision, the Chief Justice Pereira held that effectively it was too late. You couldn't rely on the arbitration argument, which would naturally fall under the discretion argument when you'd chosen to pin your colours to the genuine and substantial dispute. That is then the background to the second C-Mobile decision, which was on the winding up petition following the statutory demands, and undaunted, the company tried again to rely upon the arbitration ground and was met with the following. And if I can take your lordships, this decision starts at 1216. And in particular, my lords, having dealt with the passages in Salford Estates and the mandatory stay, Chief Justice at paragraph 12, page 1224, starts to quote from the Chancellor in Salford, the now familiar passages of 39, 40 and 41. Do your lordships have that?
Yes.
And then if I can take your lordships to paragraph 16. This is where the judge clearly says the arbitration clause is not an issue in this case because you didn't ask the court to deal with it on the statutory demand, and we're not going to retrofit the proceedings procedurally to fit the argument which you're now running, which you didn't run before. And then at 18, the Chief Justice says, and your lordships can read paragraph 18 perhaps. And so the Chief Justice is there saying she's in full agreement with the sentiments expressed by the Chancellor in respect of the discretionary stay. Now, it's right to say that she doesn't, in the last sentence, say the discretion should be exercised, save whether exceptional circumstances. But nevertheless, she recognises it is a factor in the discretion, having said she's in full agreement with the sentiments expressed by him. So that would seem to be close to, or edging close to, what the Chancellor, the same approach as the Chancellor in Salford. Well, if we then go to Jim Peng, if we may. Which your lordships will find starts at page 1809. Facts of Jim Peng were slightly odd. Would it help the court if I just gave you those facts?
Yes, please.
My lord, the winding up application, which we've called petitions for the sake of convenience, was presented by a creditor on the basis it was both a present creditor and a contingent creditor in respect of a debt that was, it said, was to fall due after the petition was presented. The court rejected the argument that it was a present creditor, so it had to fall back on the argument it was a contingent creditor, As a contingent creditor, you can only rely upon the just and equitable winding up ground. You can't rely upon the unable to pay debts ground. That's the same in BVI and England. So when you're reading it, you say you question why they apply on the just and equitable ground. That's the reason. But nevertheless, it was still treated as a creditor's petition as opposed to a member's petition, such as in Family Mart. And they argued there'd been a loss of trust and confidence, and that there was present or future insolvency of the company. And those were the two grounds for winding it up. The company argued there was an implied agreement to convert the debt to equity, and therefore it was not even a contingent creditor. So those were the three issues. My Lord, if I can take you to 42 in the judgment of Justice Webster, which you'll find starts at page 1829. The appeal judge at 42, perhaps I can invite the court to read 42. Your Lordship will notice that the court in the BVI was of the view that the debt itself and the question of standing to apply for winding up was caught by the arbitration clause, which I think is consistent with the argument I've sought to put before your Lordships this morning. In the same way, for example, that if in Family Mart there'd been a dispute as to whether someone was a member, that could have gone to arbitration for determination before the winding up petition proceeded in Cayman. My Lord, what we then have, if I can just take you to 45, the judge identified but said once the appellant submitted his dispute to the court, it became an issue between the respondent and its creditors over the company's ability to pay its debts as they fell due. My submission, that's a mistake, because the judge moved straight to stage 2, as I've described it, bypassing stage 1, and where issues about stage 1 should be determined. At paragraph 46, he refers to Salford Estate and the relevant paragraphs in relation to the discretionary stay. We don't say he ignored them, but at 47, he says the position outlined by the Chancellor in these passages comes close to the automatic stay provisions, which is now firmly part of the learning in connection with Section 18 of the Arbitration Act. He says, I do not think the creditor should have to prove exceptional circumstances. He says, the court's judgment in CMAL sets out and distinguishes the BVI's court statutory jurisdiction. He says it's too finally part of BVI law. But he doesn't at any point engage with the fact that there'd been a change in BVI law between the 2013 Arbitration Act and before. And indeed, C-Mobile, my lords, was in fact a decision under the old arbitration provision in the BVI, where you could still get summary judgment in ordinary court proceedings. So notwithstanding that, Chief Justice Pereira was still identifying the importance of the reasoning of the Chancellor. And we say it was incumbent upon Judge Webster to note the change in the 2013 Act and to address the issues which your Lordships are now being addressed on. And at 48, he misunderstood C-Mobile, because he says that decided the dispute in that case fell outside the arbitration clause. We've seen C-Mobile decided that procedurally that argument wasn't open to the company to run. And then finally, at 47 and 48, there's no recognition by him that the Chief Justice in Seed Mobile said she was in full agreement with the Chancellor in relation to matters associated with the discretionary stay. And finally, my Lords, and interestingly, at paragraph 50, he exercises the discretion. He notes the parties have already resorted to arbitration proceedings, but he says it has to be balanced against the fact that the loan proceedings, most of the loan proceeds have gone missing. I think from recollection that was over 50 million, so it was a significant sum of money. And so it seems that in any event, and you can see this from the end of 51, he would have found exceptional circumstances in any event because of the need to protect creditors as a result of the missing money, which we would say could comfortably fit within our overall framework. So we do say that Jim Peng was not well-reasoned and didn't pay proper regard to what the Chief Justice had said in the case before in relation to the arbitration provision, the old arbitration provision, before it was improved. Finally, my Lords, my learned friends, pray and aid Section 168 of the BVI Act, which provides for a 6-month determination period in respect of winding up applications, together with 3-month extensions if there are, quotes, special circumstances. And they argue that this this evinces a policy which is against the strategy or the approach which we're adopting. Because we don't see it that way. We don't accept you can't necessarily have speedy determinations within arbitration. That depends on the particular procedure that's being adopted. There was reference to prompt interim awards being noted in the Halki by Lord Justice Henry and Lord Justice Swinton and Thomas. But in any event, one could easily get, we would submit, 3-month extensions on paper, with limited cost, and if the reason a petition is being stayed is to protect creditors by the appointment of a provisional liquidator, or in order to preserve dates in respect of avoidance transactions, that would surely be special circumstances entitling for further 3-month periods. But we'd also note that in England, there is a general policy against letting winding up petitions hang around for long periods of time. There is a limit to the number of adjournments that you might get a winding up petition. So in substance, it doesn't or shouldn't lead the court to a different view about the approach in the BVI as opposed to in England and the other jurisdictions. My Lords, is there anything else I can assist you at this stage in relation to BVI law? Any questions?
No, I think not. Thank you.
So, my Lord, the second issue is whether or not, if Jim Peng is wrong, what should be the test? And then whether or not we satisfy the test. Obviously, it's quite hard to address whether we satisfy the test before we know what the board's going to say about what the test is. I think what is essentially said is that the exceptional circumstances test is too high because it ceases to be a discretion at all. And we would say that's not the case for the reason that we've identified, in that the case law is starting to identify matters which the Chancellor didn't envisage, but are or may fall within the definition of exceptional circumstances or a test of an abusive process. we say it doesn't prevent the court from striking a balance between arbitration policy, if it's found to exist, and insolvency policy. That was a point that's brought out, we would submit quite clearly, by the Hong Kong Final Court of Appeal in Gai Lam. As to the postulated alternative, my lords, of strong reasons, which is their alternative, I think, fallback case, I mean, there might be an argument as to what extent there's a difference between strong reasons and exceptional circumstances with exceptions which have been identified. How many times in practice is actually going to make a difference? And we would submit, my lord, that the run of authorities on exclusive jurisdiction clauses is now that merits should not be considered by the court. We've included within the supplemental bundle some extracts from Dicey. If I can give the court the references at 12.107 through to 12.111. That starts at page 175.
Page.
175. Where Dicey identifies, and I'm sure this will be well known to the court, the most important factors are whether there's a time bar in the chosen forum and the risk of inconsistent judgments affecting third parties. Those are the most important factors in deciding whether there's strong reasons in relation to an exclusive jurisdiction clause. There's a review of the cases in Annan, in particular at paragraph 81, page 1030, where it's concluded that merits are not relevant in relation to exclusive jurisdiction clauses. But what we'd say, my lords, is that a strong reasons alternative would have insufficient regard to the change in arbitration policy, and effectively goes back to the historic position as identified by our learned friends in their written case at footnote 9, page 844. And it fails to have sufficient regard to the fact that there is statutory underpinning in relation to arbitration clauses, in relation to both purpose and protection, in the way there isn't in relation to exclusive jurisdiction clauses. So we resist a strong reasons alternative, although we do acknowledge that in practice it may not often make that much difference. My lord, the follow-on point from that is whether or not we satisfy the test, whatever it is. Would your lordships like to be addressed on that? It's a slightly difficult exercise because we don't know what the test is. Having said that, my learned friends have identified 3 matters which they say should lead the court to reject us no matter what, and we have a response to those.
Yes. By all means, address us on this.
First of all, they say the debt is not disputed on genuine and substantial grounds. Well, just parking the debate, if we get through the hurdle and say that Jim Peng is wrong, we say you can't go back then and look at the merits again. I've just identified to the court, even in EJCs, merits are not relevant. I would just say on the facts here, it is right to say there was not a dispute about this debt when it fell due in 2018. But events changed in 2020, where we say the conspiracy claim arises, and that then became a cross-claim, which is capable of being set off. So rather like my example of the plant and machinery that blows up later, that would not be even if it was a past admission, there would be a clear and convincing reason for changing the position, and that wouldn't be held against the person doing so when assessing it. My lord, the second point is we haven't referred the dispute to arbitration. Respondents don't suggest that's an absolute requirement. Whilst conduct in relation to arbitration, as we've identified, could in some circumstances be a factor, there shouldn't be a general requirement to refer to arbitration. That comes from the LASMOS. If your lordships look at the reasoning in the LASMOS in due course at paragraph 30, no reason is given as to why there should be this absolute requirement to refer to arbitration. I just want to go back and just pick up on questions that were made, raised earlier, and I think some resistance from the court to my submissions about the relevance of the negative obligation. One could put it this way. If the court came to the view that the negative part of the arbitration agreement has no application, there's a positive duty to put it into arbitration, but you're not satisfied the negative obligation is engaged at the winding up proceedings, that could be a justification for the LASMOS requirement to refer to arbitration. In other words, if the negative obligation is not engaged, the reason the court will stay or dismiss the petition, probably stay, is because you are taking positive steps to engage with arbitration in order to enforce your right to the positive obligation. So that could be seen as a conceptual underpinning in some circumstances as to why a requirement to start arbitration is required. In other words, to engage the positive requirement, positive obligation to have a dispute determined when the negative obligation hasn't been engaged. In any event, my lord, we say on our facts, it's difficult to see why we could or should have commenced an arbitration for a negative declaration. Anne refers to a decision of this court as to some of the practical difficulties in commencing an arbitration for a negative declaration. It's not particularly practical, and it's actually quite hard to explain why you should commence an arbitration in order to say that you're not owed any money. And it should ordinarily be for the person, the party seeking the debt, to commence the arbitration rather than the party denying the debt to seek a negative declaration from the arbitral tribunal. At worst, we would say the court should give a short period to adjourn to allow an arbitration to be commenced by the company debtor to give it that opportunity to engage the positive aspects of the arbitration obligation. My lord, the third and final point is it said we issued ordinary court proceedings, which is true. And they say there's probably a repudiation of the arbitration agreement. My lord, we're not sure how this court would make a determination of that. And indeed, it appears that the respondents don't even ask you to do so. A proper tribunal would have to decide whether or not there's a repudiation of the arbitration agreement. If there is, then that's relevant. Equally, if there isn't a repudiation of the arbitration agreement, that's also relevant. And we would submit this is a matter that would have to be reconsidered back at first instance. We do not accept there was any repudiation in circumstances where we issued a conspiracy claim, which did not of itself concern the debt which was being claimed. It must be properly arguable that that freestanding conspiracy claim was not itself caught by the arbitration clause. It would only be caught by the arbitration clause insofar as it constitutes an equitable set-off against the debt. In any event, my lords, even if you have repudiation, it's not effective unless it's accepted. Acceptance hasn't been set out. And indeed, and we refer to this in our written case, we would argue at first instance that the respondent affirmed the arbitration agreement by relying on it as part of its jurisdictional challenge in the BVI. We referred to that in our written case at paragraph 12. So for all those reasons, my lords, we say those matters certainly couldn't be resolved against us. My lords, I think my time is at 12:20, 12:25.
Yes.
So, my lord, I haven't addressed you on what has been described as the case management point.
Yes.
Equally, you haven't heard from Mr. Fradley on the leave to appeal provisions. How would your lordships find it most helpful?
Well, I think it's more important that we hear you on the case management point. You can always eat into your reply time if you feel you need to.
And yes, and Mr. Fradley, I could deal with the leave point at some point in the reply time as well, I suppose.
Well, that wouldn't be giving the respondents an opportunity to respond.
Let me see where I get to with case management. My Lord, you've been looking, hopefully, at the small section of the judgment at first instance, which runs from page 108 to the top of page 112, and I hope I can take it that the court has had a good look at that section. My Lord, cutting to the chase, your Lordships will no doubt have formed your own views about what Judge Woolbank was or was not saying in this extempore judgment. We submit he was engaged in one of two discretionary exercises, and whichever it was, if we are successful on ground one, in other words, that Jim Peng is wrong to some extent or the other, that exercise can't stand. And we say our primary case is that what he was doing was considering whether or not the arbitration clause was a reason not to make a winding up order. In other words, he was at stage 3. And what he may be seen as doing is clearing out in the same way as the various hopeless points he described in the pages before, this point. At the same time as confirming his approach, his view as to the stage 1 test. As the board may have noticed at page 108, second main paragraph down, so this left the following main issues. The first one is whether the debt is disputed by Sian on genuine and substantial grounds, and that then sort of feeds into the arbitration issue as he deals with it. But it's clear that Mr. Woolbank had Jim Peng in mind, and I think I've taken you to Jim Peng at 46 in that judgment, where the court did accept the arbitration clause was relevant to the exercise of the discretion. We note that earlier in his judgment, Mr. Justice Woolbank referred to the relevant provisions giving him discretion he may appoint. And that exercise we submit is consistent with his reference to a number of factors, including the second factor, the failure to commence an arbitration. That can only be understood, we would say, as part of the overall discretionary exercise as to whether or not a winding up order should be made. It's also consistent. Actually, perhaps I'm going to leave that point for reply. So, my Lords, if that's correct, we don't see how that discretionary exercise can stand if Jim Peng is wrong. It's clearly a very different discretionary exercise if Salford or similar is the approach, rather than Jim Peng. My Lord, my alternative case, and just picking up on the arguments of my learned friend, is if this was some kind of case management exercise in order to decide whether Sian could rely on the arbitration point, you don't get to a different answer. Lord, that case management must be a two-sided exercise. You have the overriding objective under the Caribbean CPR. On one hand, you've got lateness and any prejudice caused by that. And let's just assume that he dealt with all the prejudice sub silento without actually setting it out and all the delays. you've still got to balance it against something. You've still got to say, well, you're late, so I may deprive you of your right. But what's your right? If the corresponding right you're losing is Jim Payne, which he described on one view as making the point academic. In other words, you weren't losing anything of value. The discretion gets exercised one way. If, on the other hand, lateness and prejudice has to be weighed against losing the right to argue that, say, for exceptional circumstances, there shouldn't be a winding up order, then that's a very different discretionary exercise. And you'd have to take into account a range of factors in coming to that. And so we say that discretionary exercise could not stand if you substituted the correct law for the discussion of Jim Payne. In other words, he didn't take into account matters he should have done. He did take into account matters he should not have done. And my lords, whichever analysis applies, we just submit that the knockout point delay just can't work. In neither case, as we identified, was the court purporting to carry out on the face of the judgment a one-sided exercise, nor could it properly have done so. It would always have to put matters in the balance, and you can't just simply say lateness, full stop, without comparing it to what rights were being lost as a result of that. We do say the fact he listed a number of points, 5 points, possibly even effectively 6 points, which is the paragraph starting then towards the bottom, makes it the natural reasoning. He doesn't say that point 1 is determinative or use phrases that the court will be well familiar with in saying, well, if I'm wrong about that. Reading it naturally without seeking to subvert the language, he's putting them all in the mix together. And finally, my lord, a point has been taken against us that lateness logically can't be relevant. It said it's either a good point or a bad point. You can't sort of take lateness in a sort of way. But we reject that, my lord. One knows there are cases where judges say, if this was such a good point, it would have been taken earlier. And the lateness of the point is relevant to the assessment of its merits. There's a good example of that in McPherson, in the authorities bundle at 3083, page 2510, namely in deciding whether or not there's a genuine cross-claim. The court can take into account the time at which it's raised in assessing its genuineness and seriousness. There's even an example in the BVI, the Happy Lion case, which is at page 1753, paragraph 89. The court there took into account delay in raising a dispute in the assessment of its merits. So the logic point in my submission, my lord, doesn't work. One reads the ordinary language. It wasn't a knockout point. Whichever exercise he was engaged in, if Jim Peng is wrong, it's a flawed exercise which this court should determine or should go back. My lord, at 12:25, I was proposing to stop on my points. We would be content to take 5 minutes out of our reply if you'd like to hear from Mr. Fradley on the leave points.
It would be helpful.
Yes, well, I thought it might be, and we want to be helpful, so and if it goes a little bit longer, I'll knock a little bit more off my reply. Unless I can insist any further.
No, thank you very much indeed, Mr. Morgan. Mr. Fradley.
My Lord, I'll make some brief submissions on what we called issue 4, which is whether Sian should have been entitled to appeal to the board as of right, on the basis that the appeal involves, directly or indirectly, a right of the value of more than £300. What I intend to do largely is pick up the points made in my learned friend's written case in response, and we continue to rely on points in our written case. Yep. The first point, and the important point in our submission, is that on the petition, the court was required to consider whether Sian owes Halimeda the petition debt or has a right to settle for cross-claim on that debt, at least to the standard of genuine and substantial dispute, or to some other standard. And as we set out earlier, that was relevant to both what we're calling stage 1 and stage 2. And the consequence of that, of those questions being answered in favour of the respondent, is that it is entitled to enforce its debt through the winding up mechanism. We accept that the leave to appeal provisions need to be strictly construed, and we also note that their purpose is to stop unimportant, trivial and minor litigation from getting to your lordships. But we do say when construing the language, the court should have regard to the fact that it has the means to control its own process, and the respective countries and territories that send appeals to your lordships also do. And that's the abusive process devoid of merit jurisdiction. I'll give you, my lordships, the reference for that. That's page 953 of the bundle, the decision in A&R Guernsey at paragraphs 11 to 12. The second point in our submission is that our case is supported by the relevant case law. The court will have seen we've divided those cases into 2 strands. Unfortunately, we won't have time to go through them, but what we do say is that that second strand, that's the jackpot decision, which the court will find at 1799, and the Myers decision, which is 2260, are both judicial review cases where there was no civil right involved either directly or indirectly. The distinction which Halimeda seeks to draw from the first category of cases is that essentially the appeal does not affect the civil right. And our response to that, in other words, is that there's no mandate in statutory language for that approach. The authority which my learned friends rely on in support of that is the Fletcher decision. If I could just give my lordships a reference for that. It begins at 1483. The relevant points are 1488 and 1489. And the short point we make on that, my lords, is that that's a matter in dispute case. So it's concerned with the matter in dispute limb of the test. The next point, my lords, is that Halimeda in effect says because there's no determination on the civil right, that means we don't come within the value test. My learned friend has gone through the court's approach to the exercise of its discretion with my lords. We say the court is still making a determination as to whether the debt is disputed on genuine substantial grounds, and whether the company is insolvent. And there's no requirement, as a matter of statutory language, in all the cases, for there to be a determination of the civil right. The board will see there are 2 limbs, the matter in dispute limb, and what you might term the directly or indirectly limb. Of course, in the matter in dispute limb, there will almost always need to be a determination. But we say requiring a determination for the second limb collapses those limbs. The final point, my lords, is that in their written case, the respondent says that the fact that we're now on appeal before your lordships makes a difference to the application of the test. We say it does not. The appeal still directly or indirectly involves Sian's obligation to pay the alleged debt. The substantive question on ground 1 of the appeal is the approach the court should take to assessing the merits of the alleged debt. We say they're both issues that directly or indirectly relate to the petition debt. The question of the test the court should adopt, considering the merits of a civil right, in our submission, at least indirectly, involves that civil right. My Lords, that was all I was proposing to say in amplification of our written case, unless my Lords have any... I apologise, it's a bit of a canter.
Thank you very much, Mr. Fradley. Mr. Lowenstein.
Lord, may it please you and the board. Firstly, I should ask as a matter of politeness whether the board wishes to have a comfort break at this stage of the morning. There are no shorthand writers, and it may be that people need 2 minutes. I'm happy to give up 2 minutes of my time.
I think we can carry on until we can endure it till 1 o'clock.
For the bitter end. Lord, the points you've just heard will be responded to by my learned junior, Mr. Hamilton, in due course, and if he reminds me to stop in good time, then he will have plenty of time to answer. The order of my submissions, with your Lordship's permission and subject to any directions, will be this. One, that the arbitration clause argument was excluded by the judge on case management grounds, and that was upheld by the Court of Appeal as being eminently reasonable in the exercise of the judge's discretion. If that's correct, that's the end of this appeal. I'm afraid it takes away all the interesting points of law.
Well, that rather shoots our fox.
It does, and I'm sorry, I don't want to take away the fox, and I will address it, but we say for that reason and the next reason, the court never gets to the interesting points of law, and so if it wishes to deal with them, that would be by way of obiter dictum. The second point is this. It's the whatever test on the merits. We met them. That was decided on the ordinary test, but we say even taking the most extreme test, which is the Salford test, we meet that test, and that also is a matter of the application of the facts to whatever test your Lordships decide is correct, would be the end of it. If I'm wrong about those, then my third and fourth points are these. They're linked points of law. The area 3 is that the BVI law is different and should be allowed to be different. Even if Salford is correct in England, Jinpeng applies and has applied for many years in the BVI, is regularly followed and should be left to stand. And then fourthly, exactly the opposite order from our learned friend's submissions, Salford is in any event, with respect to the Chancellor, wrong. Lord, if that's convenient, I propose to then start with 7 very quick fundamental propositions, which will, I hope, inform all of my submissions, and therefore allow me to take further matters more quickly. I'll number them as I go. Proposition 1, default in payment is sufficient evidence, with the word evidence underlined, of inability to pay on a winding up petition. C, for assistance on that, the work of Professor Good, Authorities 83 at 2502. See also the evidential rule as it was referred to in Salford itself at 29, 2284, and at Salford 31, where the Chancellor said, as evidence that the lessee is unable to pay its debts as they fall due and so forth. And see also the salutary rule, which I'll come back to in Professor Good's work. The salutary rule being that the salutary rule applies, I'm now quoting, on the failure to pay even a single debt that reflects the view that a company which is able to pay an undisputed debt and chooses not to do so has only itself to blame. Tough rule, but applied every day in the Companies Court, as your Lordships know. My second proposition is this. On a winding up petition based on an unpaid debt, the Insolvency Court need not and ordinarily will not finally determine any issue or dispute that the parties have agreed to refer to a different court or tribunal, because its function is different. The Chancellor in Salford at 31-2285 observed that a petition is not a claim for payment. I think this was Lord Briggs' point put to my learned friend earlier, and also Lord Reed made the same. In the case of White against Eckard Marine in this court in 2003, page 2452, Lord Hoffman said, a winding up order is not the equivalent of a judgment against the company which converts the creditor's claim into something judicially different, like a judgment debt. That's paragraph 26 of the judgment. Lords Reed, Briggs and Hamblin will remember the appeal in Bresco in the Supreme Court just 2 or 3 years ago, in which it's an example of claims surviving, winding up in the context of insolvency set-off, where those claims could be sent to arbitration or to litigation. The winding up didn't extinguish the claims, they survived to be resolved on another day. Fundamental principles that underlie all of this. The third principle, if I may, that I was going to call it Sian, but out of respect to Lord Lloyd-Jones, I'll call it Sian, has not articulated any dispute on genuine and substantial grounds. It says it has, but its position is tenuous as established by the SOFI, the Statement of Facts and Issues itself. May I take this in stages? Would your lordships turn to the SOFI, please? That's starting at 783. This was a heavily negotiated document, and we say because it was necessary for Sian to be cute in the way it puts its case. It always has been. So, SOFI 7 and 8. 7, Sian owes Halimeda a debt due under a facility agreement. It owes Halimeda a debt. Sian disputes this debt is due and payable on the basis of a cross-claim or set-off, albeit that the courts below have held that such dispute or cross-claim or set-off is not genuine and substantial, and then critically, and Sian does not maintain any appeal against those findings. For your lordship's purposes, this is an undisputed debt. Going further, at 33.1 in the same document, 789, please.
Sorry, paragraph?
7.8. So it's paragraph 33.1, my lord. 789.
Thank you.
These are the issues to be decided by His Majesty and Council. 33.1. The matter of BVI law, what is the correct test for the court to apply to the existence of its discretion to make an order for the liquidation of a company, where the debt on which the application is based is subject to an arbitration agreement and is said to be disputed and or subject to a cross-claim, and then brackets, notwithstanding that, critically, notwithstanding that dispute is not on genuine and substantial grounds. It's common ground that any dispute will not be on genuine or substantial grounds. And we say that means that it must be a spurious opposition in the sense identified in the case in which Lord Hamblin was counsel, I think, in the Hulkie. So the formal position on the debt is that the only possible issue was the asserted cross-claim, but that has gone away because of the agreements between the parties. Sian hasn't appealed any of those results and has not replaced its argument by making any claim anywhere else.
What
has
about the
not.
conspiracy claims?
I'm so sorry.
What about the conspiracy claims?
Yes, they're abandoned. So it's conspiracy claims. This is the point. Because I'm going to say that this case is really a ruse or a trial. What happened is that in the BVI, Sian brought an action by way of trying to kill my petition. With others, there was one of, I think, 6 claimants, a number of defendants, and it alleged unlawful means conspiracy. That claim was withdrawn in July of last year, just days before a jurisdiction challenge, which my clients had brought. There is no extant claim at all against my clients in the BVA. That's the first point. Lord, the second point is this, that another one of the claimant group and my clients are locked in battle in the LCIA Arbitral Tribunal. Maple Ridge, Sian's subsidiary, is sued by my client for their debts in the LCIA. A panel, this is all public because it's been referred to in court. A panel chaired by Sir Jeremy Cook and with 2 others, has decided preliminary issues in that Maple Ridge claim, and Maple Ridge brings a set-off defence there, making all the conspiracy allegations. Sian has never applied to join that arbitration. Thirdly, following the withdrawal of the commercial court action in the BVI, Sian and a cast of many have brought what is trumpeted to be the biggest ever fraud claim in the commercial court in London. They claim $13 billion. The reason I tell you that that is also of no assistance to Sian is that its potential claims against my client are expressly excluded in those proceedings. The statement of the particulars of claim excludes any money claim by Sian against Halimeda in those proceedings. So the position on the ground, and this is why I take these matters as preliminary facts, is that although Sian asserted it wished to go to arbitration to raise these conspiracies, it has never started an arbitration. Lordship knows that. It has withdrawn its BVI claim. It does not claim in the commercial court in London, and it has not sought to join in the one tribunal where these issues are being tried, albeit by way of set-off defence. The final hearing in that tribunal is in the autumn of this year. It's set down for a 3-week trial.
How would they get involved in those proceedings?
Well, they could have issued their own arbitration, and then said that because the issues are the same, they could have asked whether or not there would be consent to joining or case managing those 2 proceedings together. It wouldn't have been a formal mechanism, your Lordship is right. But the fact is that they haven't done anything about it. The fourth point is this, that a petition concerning a debt based on a contract which contains an arbitration clause is not subject to a mandatory stay under the arbitration legislation, either here or in the BVI, and that is common ground. That point has been put several times by the board to my learned friend. It's the Section 9. People have said this, and Section 8. It's actually Article 8 of the modern law. In BVI, just for your Lordship's notice, Section 18 of the relevant Act, which incorporates Article 8. The reason it's common ground is my learned friend's written case at paragraphs 17 and 28. Your Lordships know that's because a petition is not a claim under Section 9 and not proceedings, I think, under
Action, I think.
The next point is critical as it answers my learned friend's arguments in relation to discretions. An insolvency court presented with a winding up petition has at least two separate, distinct discretions to exercise. The first set of discretions arise in its case management of the process, including as to the admission of evidence and arguments. Nothing to do with the merits discretions that come later. And we say, as your lordships know, but just to nail this down, that the lateness point is a prior case management point where the judge, faced with chaotic and abusive conduct involving two adjournments, repeated documents filed, and even a debarring order saying no more evidence, and then they issued a strikeout application to get evidence in, and then forgot to issue the application for the further evidence, and then did that ex post facto. Faced with all of those matters, which I'll develop in a few moments' time, it's just headline, the judge excluded the lateness argument and the error as a matter of case management. My learned friend's best point on that is where the judge put out a list at the beginning of his judgment, a relevant part of 5 matters he was going to decide. But as I'll demonstrate, the list contains several different matters which arise in different contexts. Because the second discretion is the critical discretion. It's the ordinary discretion on a winding up petition. So the court has 2 stages, whether or not the dispute is opposed on bona fide genuine grounds here, or substantial bona fide grounds, or substantial and genuine grounds in the BVI. And then there is a residual discretion whether to wind up or not to wind up. And this court has said, for example, I think it was in the Primark case, the Family Mart case, I'll come to that accurately in due course for your notes. The residual discretion may say, notwithstanding that you have ticked all the boxes to go one way, the judge says for special reasons, I will go the other way. I have a discretion. I will have discretion not to wind the company up, even though you're qualified for the test on the rules. Or I will not, or I will wind up, even though you have. So the second discretion arises formally in the BVI under section 162(1) of the Insolvency Act 2003, page 899, and in England, of course, everybody knows, under section 122(1) of the Insolvency Act, page 914. The 6th point is this, that since Sian conflates and mixes its analysis of those discretions, the factors that arise, and I say this because of that conflating and mixing, the factors that arise on the exercise of the case management discretions are different, obviously, from the factors that arise on the substantial discretions, the merits discretions. Because when case managing, as every judge knows, the court needs to take care to balance the things that should be done against the things that shouldn't be done, and to bring the case forward in an orderly way for resolution. When you get to the resolution part, then you have to apply the law and exercise discretions in the ordinary way. I'm afraid learned friends' arguments don't separate out those discretions for obvious reasons. And then lastly, and I apologise for mentioning this, but just as your lordships will always know, an appeal court should not interfere with an exercise of discretion by the judge at first instance, and we say a fortiori on a second appeal, and even more so where this is a case management matter. So those are my 7 points, and with your lordship's permission, I will then develop, before I hope the short adjournment, the discretionary case management exclusion. So the point in a nutshell, the issue that the judge decided and the Court of Appeal upheld as being, as I've said, eminently reasonable, reference paragraph 52 of the appeal, page 58, was whether the arbitration clause argument as a whole had been raised too late. And as I say, that was an exercise of the procedural or evidential discretion. It's separate from the merits determinations. And being a case management decision, and this being a second appeal, this court should not interfere because, one, the judge's decision was not irrational or perverse, and Sian doesn't say it was. They tried a little bit today. But they don't say it was, and it's not a grant. Secondly, the Court of Appeal's decision to approve the judge's exercise of discretion cannot be impugned because they, at the relevant passages, go through what the judge did, set out the tests, and then from paragraph 47 onwards, pages 5, 6, 9 onwards, 47 and onwards, then the Justice of Appeal gave the legal judgment, reminded herself that she shouldn't overanalyse the decision below, looked at the arbitration point of lateness, she reminded herself of the provisions of the local legislation over 3 paragraphs, and then the 52 critically, this is page 5, 7, 9, she said that the reference provisions demonstrate that the company faced with an application to wind it up, in a matter that's subject of a valid normative arbitration agreement, must file and serve a request for a referral to arbitration not later than the date of submitting its first statement. Sian's first substantial statement to the court regarding the dispute was the notice of opposition that was only filed after the time limit in 164, but it did not raise the issue of arbitration. Now, Lordships will have seen from the chronology in the SOFI and so forth that they had raised the arbitration matter in correspondence right at the very beginning. And in fact, one needs to be slightly careful around the skeleton in one footnote where he says this was raised early. It wasn't. It was raised and then not pursued. They raised it, then they ran the case, but didn't take the point in their notice of opposition. Again, I'm not slavishly asking the court to say that was too late because they didn't follow the rules. I'm saying that the judge held that they not only didn't raise it in accordance with the rules, but then raised it much later on and in a chaotic fashion with a case that was developing through the means that the judge explained in his judgment. And in the rest of 52, the Justice of Appeal who decided the case said that it didn't raise the issue of arbitration, neither party invoked Section 18 of the Arbitration Act. The difference, that's the statutory demand provisions. And then for instance say, well, the Court of Appeal went wrong by raising that. But they didn't. The only reason they raised it because it had been put to them by my learned friend's predecessor. Learned friend's a third silk on this case, up for the other side. So in the first instance, the advocate on that occasion put to the Section 18 argument came in and went out. It was one of the many arguments that came in and went out. They said you should have issued a statutory demand, and they saw better if it and took it away. The Court of Appeal, they then made an argument which came in and went out. There were many, many arguments which came in and went out at each stage. And then they complain now that the judge referred to it. Well, the only reason the judge referred to it is that they... Then the critical part, in those circumstances, the learned judge's statement and ultimate determination that the issue of arbitration was raised late, thereby invalidated, is eminently reasonable, being, as it was, grounded in the factual background.
Sorry, where are you
I'm
citing
reading
from?
52 at the top of 580, and I'm about 6 lines into that before the end of the paragraph. So,
Paragraph 52.
52 of the Court of Appeal, page
Yeah.
580.
580.
Yeah.
I believe it is.
127 of the...
Oh, is it 6? Sorry. 58. I'm sorry, I'm giving the wrong paragraphs. I've got it printed in the numbering scheme.
No, it's 50.
Page
It's
50.
paragraph 52.
Paragraph 52. Page 58, paragraph 52. In the electronic bundle. I'm sorry, this is my fault.
Right.
Page 58, paragraph 52.
Thank you.
Starts at 57 at the bottom, and the critical paragraph after reference to the Arbitration Act is in those circumstances. And the court is endorsing the judge's exercise of discretion, being as it was grounded in the factual background and supported by the legal provisions underpinning the order for automatic referral mandate. For those reasons, and of the considered opinion that Sean's argument, the learned judge erred in law on this score being the lateness argument, is not sustainable. Then she feels the matter which I've just glossed over at 53, and then at 54, as to the contention that the learned judge erred in the exercise of his discretion by holding that the arbitration point was raised too late, Sean has neither identified any relevant factors to which the judge attributed either too much or too little weight, or any irrelevant factors he took into account, which constituted an error in principle with the result he made a blatantly wrong decision outside the ambit of reasonable disagreement. It's very rare that in this court one's looking at the exercise of discretions, but I'm afraid it's been put before the court. It's been necessary to do it. I perceive no such deficiency in his analysis. I would not interfere with his decision. I therefore dismiss, and then the relevant ground of appeal. Now, that's the beginning and the end of it, and that's the beginning and the end of this appeal, in my respectful submission, because the court there was dealing with case management points. The Court of Appeal, just so your lordships know, dealt with this case over 2 days and had very full argument, almost as full argument, probably more than the judge had. And I've shown you what they said. In terms of discretion, if I need to address the approach of the Court of Appeal, first of all, the court made no error of law in that part of their decision, and none has been identified. And secondly, they didn't make any findings of fact or exercise their own discretion. All they did was quite properly endorse the judge's discretion. Now, a learned friend says that lateness, this is his written case at 89, lateness was simply a factor amongst others in the judge's exercise of his discretion. He points to lateness being dealt with as one factor in a list of 5 issues for determination, and that is in the SOFI at paragraph 24, which one will find at page 786. I very much hope I've got that right. 786, it's set out in terms. John's reliance on the arbitration agreement in the loan agreement is a hopeless objection, so there's the whole of the argument. Why? Well, it was raised late. Sean was aware of the point sufficiently early, but chose not to use it. They then changed their mind and sought to introduce it via a strikeout application. Stop there. That was his description of that point. Then he moves to the next point, failed to commence an arbitration. They invoke the arbitration agreement. They've not sought to bring one. Instead, they've started claims on matters that would require arbitration on their case, or might require arbitration on their case, but they haven't done so in an arbitration. Thirdly, reference to arbitration agreements is entirely academic. Fourthly, it's not the law. Existence of the arbitration agreement means that a creditor cannot invoke a collective. And at 4, then moving to the merits. He's moving to the merits decisions he's got to decide. So the first three are not factors for the merits. Certainly the first one is not a factor for the merits. It can't be. The first one, raised too late, cannot go to the merits, and of course didn't go to the merits. The court was deciding on my submission whether or not to rule in or rule out that argument and the evidence in support of it. And I prevailed. And fifthly, he refers to no mandatory stay. And Sian jumps from saying, well, there are 5 factors, so all of them must have been raised on the merits, and therefore they've gone wrong. But I say that's incorrect. Now, I'm not going to develop this any further now because of time, but we give our answers.
Mr. Lowenstein, is that then perhaps a convenient moment?
Yes, of course, my lord.
Very well. Well, we'll adjourn now and resume at 2 o'clock.